validity of that Section 500A of the Act that the decision on relations to the listener as an effect of the listener to have abandoned the security and isolated the operations of the supporting ministers and issues. Such as to require the court below to exercise discretion was misplaced. The decision of the minister and the declaratory order, as I have already said, cannot coexist on the same issue. In the ordinary matter, the decision of the provincial administrator to grant approval of the township was found to be invalid, but for the reason that it was not set aside, it remained valid and the declaratory orders sought were refused. I therefore conclude that the respondent is not entitled to the declaratory order granting which the manufacturing status sought in paragraph 3 and 4 of the notice of motion. However, there is a South African judgment of Serengeti rights, and we don't have it in our heads because this point was never anticipated that there would be a debate as to which is the primary relief. On the papers, it was common call that the primary relief is graph 3 and 2, 3 and 4.
Where is that common cause? No, this is fundamental to your argument. Where is that common cause of that primary relief? I don't understand this point, really.
It is common cause from the head of arguments that they specify what is the primary relief that is seek and that the rest is consequential. So I'm coming also to the very submission that the made before the court where it was mentioned 5 times that you either give us a declarator or you are out. So that is the position. But I want to refer to the South African authority on the primary relief and the consequential relief, and that is now Serengeti rights industries. It is reported in 2017, volume 6, SA, page 581. And I'm going to refer to paragraphs 11 and paragraph 12 of the judgment. I'll read it from the judgment itself, and also it related to the order which was granted by the High Court for the demolishing of the property without having reviewed and set aside the approval plans that were granted. And the Supreme Court and the Court of Appeal said the following in paragraph 11. In my view, the insurmountable problem for the respondents in this appeal lies with the order granted by the High Court. In relevant part, the order is the development of the property situated at 317 Carry Road that exceeds GR1 zoning be demolished. This order is unsustainable for a number of reasons. In paragraph 12, the court said, firstly, although in its reasons, the High Court found that rezoning and deviation approvals were invalid and should be set aside. It made no order to that effect. The court therefore granted a remedy of a consequential nature without granting the primary relief sought. However, this consequential relief depended upon the rezoning and claim approval by the municipality being reviewed and set aside. Until set aside, they remain valid and have been in effect. The building thus complied with the building and zoning approvals of the municipality that remained extant. So the authorities are very clear, and that's why the applicants want prayers 2 and 3, because they know that the other prayers are dependent on it.
May I just find out, Mr. Walker, I haven't read the case.
I'm probably
I'm saying, beg your pardon, I'm saying I have not had a benefit of reading the case, but did it implicate any constitutional principles in any way? The Serengeti.
The constitutional principles?
Yeah. Does this case?
No, I mean, it deals with the primary and the primary relief and the constitutional relief.
Yes. Yeah, but what I'm saying, the kind of relief that was sought in that case, does it in any way, the letter, Does it implicate any constitutional principles?
No, it involves an inherent right.
Yes.
So I'm not arguing in the context that it was a constitutional
You
matter.
understand? I just want to clear my mind.
Yeah, no, it didn't deal. So, just to conclude, what I'd like to tell, that is now in respect of Paper 4, which is to set aside the decision of the ECM. I just want to conclude this point so that we move to the next point, Section 168E of the Electoral Act. And that section deals with the powers of the electoral court and it answers, of course, the question that was put by Justice Manga to the argument on why they didn't go to the other forum. Paragraph E, it says the electoral court has the power to review any decision of the commission related to any electoral issue. And then F says, here it determines any matter which relates to the interpretation of any law relating to electoral issues referred to the Commission. The court will remember that several times the government have been saying that, yeah, well, you can just give us a prayer form. But when you go to the list of motion, the court will see that prayer form is squarely located within the order that is saying that this court must set aside the decision of the electoral court. And we say that it's not one that falls within the explicit jurisdiction of this court.
I think he was referring to prayer 5. I think he was repeatedly referring to 4 instead of 5.
Yes,
fairness to Mr. Goldberg.
a mistake on this part.
Yes.
Fine, I said that, but I'm addressing now to prayer form. I'm saying that it does not fall within the explicit jurisdiction of this court and also because I defend the court into Section 168. But of course, in the five is concerned, I dealt with it in the context of paragraph 6, 7, and 8 of the Parliament Act, which gave the next year to what is the common belief and of course what we say in the So this court should, as Mr. Goldberg has already pointed out, we are either in or out. So we say that on the submissions that we have made, they are out and the court should simply taking on this ground of jurisdiction. So the next point that I have identified in the unreasonable delay, which I'm not going to spend a lot of time on it because the delay is decided on the basis of effects. It is a factual inquiry which must be determined with regard to the papers. What we raise as a delay is that they have known as way back as 2014 that the minister has promulgated the Electoral Act in a manner that is done, and as a result of that, the 2014 national presidential, national assembly and presidential took place, and also the by-elections and local government elections took place, and they did nothing. The court will not find a single answer or a single explanation as to why they delayed 5 years. What we're told today is submission by Mr. Goldberg is that my client, and was surprised why he refers to my client because he has said that he's representing 5 applicants. So now the question, now we're told that my client, which is the first applicant, was only became a presidential candidate in respect of the 2019 elections. We said that does not answer the question. Neither is there any explanation even from the bar about the other applicants. But even with regard to the first applicant, there is no such explanation that actually I did not do anything because I did not have to understand. But of course, what the government doesn't see is that there is a matter of importance that the first applicant concerned him. He said that it is a ministerial determination and which it does not dispute that it's no longer since 2014 and nothing prevented him from Shimano, of the South African Constitutional Court, cases such as Buffalo City.
Yes, but none of those cases concerned legislative action. What if you've cited South African cases, even though this court has dealt with this issue on several occasions. I see there's only one judgment of this court referred to in the footnote. But what authority have you got in respect of legislative action? And how do you say, what do you say in response to something like a collateral challenge? There's no time limit on a collateral challenge. What happens if you charge with a criminal provision which turns out to be unconstitutional? Surely you can raise it in those criminal proceedings. That's been the authorities of, that's been the position in the law of this country and the country where you come from.
Yes, I think Justice Master, and let me answer it this way. Whilst you correctly point out that the cases that I'm referring to did not concern themselves with the legislation or the combination of legislation, what they did concern themselves with is legality. And of course, then these applicants are coming on the legality. So what the court said is that both in respect of legality and South Africa, of course, we have a legislation called Part of Promotional and Complete Justice Act, which prescribe that you have to approach court with a clean case, but that's only when we are challenging an administrative decision. But then the court also then will pronounce themselves in respect of legality. So I'm addressing myself in respect of legality, that we still have to demonstrate that you did not unduly delay. So I'm answering in that context. And I'm not for a moment suggesting that they will involve themselves with the legislative challenge. So I'm saying that there is an undue delay which is not really explained. And of course, it is explained, the court has the power to condone, well, they're not condoning because those justices are saying that we do not necessarily have to make an application of condemnation, but you still have to explain the delay and the court can overlook it. So the ways that the court uses the court will overlook it. So here we're saying that there is just no explanation whatsoever. So that's the point that we're making. So there is nothing left for the court to exercise discretion at all. So that's the point that we are saying. And I'm also going to make something in this submission when I deal with an appropriate remedy, because the fact that the court also takes into account, even in circumstances where the court decides to overrule the overruling. The only answer that the court will find in the plan, insofar as the delay is concerned, in the plan affidavit is that when the first applicant became aware about the decision of the ECN that it will use EVM to plan the criminal trade only on the 21st and 24th of October 2019. But that's not the issue. That addresses Prayer 4. So that addresses Prayer 4, but in respect of Prayer 4, it does not fit within Prayer 4.
And duties of relating to transparency and the free and fair vote, and also duties with regard to the voter education. And there's a very clear press report indicating that she stated that there would be paper trails. There would be a paper trail with the verifiable paper trail with elections. In a few weeks ago, there's a denial of that statement. I would have thought that a person of that public office, where public voter education is so critical, would have denied any inaccurate report. But what makes the denial even more suspect is there is no other version put up. She doesn't say, actually, I said this and this is the text. What kind of denial is that?
In the context of today, I pointed out in the context of the conduct of the commission. The conduct of the commission.
Yes, I'm asking that question now. Is that the commission repeatedly has made allegations concerning participants in the election in a very majority of election. Is that appropriate for an office which is an independent office which has conducted free and fair elections, where you make such majority statements about people engaging in those elections? And I'm also raising the context of this denial, which would seem to me an application of all the principles that denial is unsustainable. It's untenable, isn't it?
Okay, I'll have to answer you in two parts, as you have raised it for two reasons. Firstly, it was raised to deal with the issue of today, rather to deal with the issue of content. So let me deal with it in the context of today. First, in the context of today, I referred to the prayer that has been sought. But that prayer has nothing to do with the statements of the commission having to say that it will use ABM to the paper trade in the coming elections. So that's the answer to the question.
Why would they come to court if the commission is undertaking that paper trail? Wouldn't it be a waste of time to come to court? Why would it come to court during the verifiable paper trail?
What is not a waste of time, and of course when I deal with that, I also point out to the document that was penned down by the first applicant himself from page 63. That actually, that would not be, it would not have been a waste of time. But let me deal with the second part, because it has been raised as well about the content. But the content of the ECN, what appears clear from the papers, and there is an extensive explanation in the answer affidavit of the ECN, is that it has been explored the possibility of introducing the paper trail in electronic voting. And one looks at the letter at page 199, which is the boundary of the fracture, which was addressed to the minister. And what is clear is that there has been an investigation in order to explore the possibility of introducing the paper trail. And that is for plausible reasons that first, the Act has been entered into operation with the exception of Section 97, 3 and 4, which involve the paper trail, and what the Electoral Commission was investigating beyond that promulgation was the practicality and the readiness of now introducing the paper trail. And once then it finds that the use of paper trail can be implemented, is then that the minister will consider putting into operation the remaining part of Section 97 into operation in terms of Section 209. So that explanation has to be dealt with, because in some motion proceedings, it has to be dealt with in the context of council evidence. And that version, in order for the court to reject it, it must find it to be untenable. And I submit that based on the council evidence, that version should prevail. So that is insofar as the conduct of the ECN, but on the delay, all the subject is that there is just no answer. And the court also has a discretion to overrule
have confidence in the Commission in having a trial. I say that this is what we do in the trial, and we are only significantly in October 2019. That's the last one that he said. He's still but then answer the question as to why would they come to court? Because the answer the answer I said in one of the papers that I didn't go to court. And that's what it says. And indeed, we went to court. Went to the electoral court in Dawson. Sorry, in confessed, we went to the electoral tribunal. He went to the electoral court. So the question of why did they go to court? And that's what happens. We don't know the answer. So the answer is these papers. So I'm saying that before this court, there is just no explanation. And I'm saying that the cases that I'm referring to are relevant in respect of the delay, irrespective of whether it is a legislation. The applicants are saying that as long as it concerns the legislation, we don't have to be enunciated, but we say that it's only in the context of the explanation. So we submit that this is a factor that the court is taking into account, saying that this delay, it prejudices the respondents, it prejudices the public interest, and the court should.
So why did they have to go back there? When they were there in November?
tribunal did not decide the matter on the merits. It said that we have come to this tribunal in respect of matters which fall outside the tribunal and was going to the electoral court. But in the electoral court, the judgment is attached to the founding papers. It never said that it was a jurisdiction. In fact, the electoral court dismissed them on different grounds. So that I've said that they have leading to the election, very close to the election, taking steps to go to the right forums that is supposed to go to. But I'm saying that doesn't make an inherent amen, because it simply solidified the point that this court and this city as a court of first instance is supposed to. And there's an issue in the electoral court, often that they've lost. Then I say that the electoral court said that it's not true. And we look at the judgment, it's attached to the form of the what is the electoral court saying? It's said that it didn't set it down properly in the system. That's not what. So since that time, we have never taken a step into it. So we know that the electoral court does have jurisdiction.
You see what worries me, Mr. Mukari? This is an apex court.
Yes.
And for us to be saying people must go back to another court to ventilate these issues of such importance, public interest of justice, I just don't understand. I mean, it's also cost involved. Apart from the issues of disciplinary motions, it costs taxpayers money to go back to the high court, to electoral court, and do the same thing almost. At a practical level, interest of justice level, public interest consideration, governance, democracy, is that really be allowed? Simply because people delay it? Should we even consider perhaps saying, because you're inconvenience the cost of the other parties, maybe you should be master in cost rather than not listening to them? That counts. It is one thing to say you have delayed. We know condemnations are granted all the time. Sometimes courts are inconvenient. But those are procedural issues. You still have to get to the substance of the dispute between the parties. The rules of this court, the High Court and this court, do tell us that disputes between parties must be resolved as expeditiously as possible. It is even worse here when we deal with such matters of important factors. So my worry is why purely on delay, if we find that they have delay, should we unsue them?
Jessica, first of all, I'm not saying purely delay, but let me say that I appreciate all those concerns that are raising us. But unfortunately, it's not a part of equity. This is a court of law which exercises its jurisdiction in terms of the Constitution, where it exercises inherent jurisdiction, constitutional rights, and where it is supposed to seek the court of first instance than the Constitution specifies. I can understand all those things that, it's really that, in any event, they are already There must be explanation. That's what I'm saying. And then Bible simply says, yes, you can overlook it even if you find that there was a delay and the explanation is not acceptable, but I will deal with it when I have.
So what I'm to Chief Justice
was on the interpretation of Section 209 of the Act. The minister entitled to bring into operation the Act, in particular Section 7, in its the word of the section. And he said, this also entitled to do so because Parliament has enacted Section 87 as a composite of intermediate provision section. Our answer is the following, and of course, certain answers firstly, this promulgation does not reach the separation of powers, because that is one point is raised by the applicants. Because Parliament, when it passed the Electoral Act of 2014, in Section 209, it delegated the power to bring into operation to the minister, and also the gave power to duplicate different days, the second provision come first part later. So the separation of powers doesn't happen in that respect, because there is a Parliament which enacted Section 209 to say that that will be done. And in fact, we have there is nothing more when the Parliament or the legislature delegate to the executive the execution of certain functions. And this is precisely what Parliament has done. But so then the complaint of the applicant should then be limited to only one issue. Because this one of whether the promulgation and the severing can be done by the executive, then that one is settled. So the issue is, insofar as Section 97 is concerned, could the minister sever it and say that 3 and 4 will come in later, but 1 and 2 then come in now? We submit, yes, the minister was perfectly entitled to do so, because the reading of Section 209 does not preclude the severing of the provisions in a particular section. All what it says is that the provisions, and what the provision is what the Act will be saying in one or the other provisions. So there we say that there is no illegality in that respect. Maybe it can come to the question of rationality. That was it rational for the minister to implement 1 and 2 and delay 3 and 4. So it is not a question of whether he's permitted to do so, because we submit that on the reading of Section 29, he's permitted to do so. But when you deal with it on rationality, one has to look at what was the rationality behind it, and that is explained by the ECN in the answer affidavit, that the machines that were purchased in 2006 did not have a paper trail. And the court would have seen that the expert opinion of Rao makes it very clear that those machines do not produce a paper trail, and that is what we disputed. And in fact, it's not even disputed by Shihama, who is the expert of the applicants. All what Shihama says is that the machines that are capable of producing the paper trail, but the evidence of Brown, who is employed by the manufacturer, says that they don't produce the paper trail, and the ECN itself, which administers this machine, say that they don't produce the paper trail. But in fact, I don't even have to belabor this point, because it is common cause between the parties that these machines don't produce paper trail, and these are the machines which were bought in 2006. So the machines, but we accept that Parliament, in enacting the Electoral Act in 2014, in particular Section 97, had in mind that there must be a paper trail which will be able to show the voter what is voted. And Mr. Gauntlet is correct on the first part when he explains what that paper trail does. It's not something that you can take home with. It's something that once a voter presses a button, it will then just show up to show that you voted this person, and then from there it disappears. But then Mr. Gauntlet says that it serves another purpose. That is when there is a dispute on the election. Of course, we don't dispute that subsection 4 deals with that part, but that will only be enforceable if that section has been implemented. And the ECN says we have put in place checks and balances, because there's no dispute between the applicants and the respondents that the purpose is checks and balances. So we said that we have put in place as the ECN checks and balances to make sure that in the event of dispute, that there are checks and balances to ensure that you are still able to verify the results. So we have put in place those, so that the issue goes to rationality. Justice Officer. Yes. That's not, that's the same thing. So I say the same thing. I say, remember that as a point of departure, I'm saying Parliament has enacted Section 97 with a view that a paper trail should be used and it will enable the voter to see. So we are on the same page. But I'm saying that once the minister promulgates the act in a manner that is done, only 97, 1 and 2. The ECN then says, because ECN could not implement a provision which is not in force, which has not come into force, because you are still going to challenge that and you are allowed to do that saying that you can do or which is not in force. So the ECN says in its affidavit, we put in place checks and balances. But what they're saying, they're not saying that those checks and balances are inadequate. They're saying that they're not provided for by law. So therefore, those checks and balances can be done. But we're saying that, coming back to Article 5, Article 1 of the Constitution, the ultimate objective of elections is that the will of the people should be realized on free, fair, transparent, and credible elections. And I mean, the rain is making it to be more difficult for me to hear. When the rain has subsided, I only had the last part.
It's not the rain so much. I think somebody is trying to get frustrated. Yeah. The point is, it's a difficult Parliament has ordained that the use of EVMs must be accompanied by international. And Parliament has put in place provisions in that effect. In making the determination that the minister has effectively undone that what Parliament has ordained to appear to me. Is that any sensibility? Here the argument that Section 209 does not include the minister from doing what the minister is not included by Section 209 for what he has done. But the point is, it would appear to me that what the minister has determined has